Let's understand subjects of international law in this video. We'll explore who makes rules, who has rights, and who is bound by international law today. Have you ever wondered whether countries, people, or groups follow the same rules between each other, like classmates following simple school rules together? One key question is, who can make international law? Is it only states? Or can other actors create rules that bind others? Another question asks, who holds rights, duties, and powers under international law? Who can claim benefits or must follow duties in practice today? We also ask who is governed by international law directly or indirectly. For example, countries, international organizations, and sometimes individual people today. Dixon explains the subject of international law is any entity recognized as able to possess and exercise rights and duties under international law. Starke says subjects of international law are those with legal personality, able to exercise rights and duties before international courts and protect interests. Oppenheim calls an international person one who holds legal personality and enjoys rights, duties, or powers created by international law today, often clearly recognized. There are three main theories about who the subjects are in modern law: the realist view, the fictional view, and the functional view. The realist theory says states alone are the only subjects of international law and carry primary rights and duties between each other. Oppenheim argued that international law is mainly about how states act toward each other, not directly about their individual citizens, usually in practice. Under realist thought, if individuals have rights internationally, those rights are claimed only through their state and not by individuals themselves usually. Critics say realist theory ignores individual rights and fails to explain when individuals commit international offenses and how they should be punished properly today. In the reparation case, the International Court of Justice held that the United Nations can bring an international claim against a state for injury to its agent. The fictional theory turns the story, arguing that individuals alone are the real subjects since states lack a separate human will to hold rights directly. Kelsen thought international laws ultimately apply to individuals and aim at their welfare, making individuals central to the legal view he proposed. But critics of fictional theory point out that the central concern of international law remains states, and individuals cannot easily enforce rights on their own. In the Mavromatis Palestine concession case, the court noted it is an elementary principle that a state is entitled to protect its subjects abroad. The functional theory takes a middle way, saying states, individuals, and some non-state entities may be subjects when they perform certain functions or hold particular rights. Moderate strict views and stress that legal personality depends on the role and rights needed for the tasks an entity performs. Modern practice shows individuals have gained international legal personality in limited ways, allowing participation but not equal standing with states generally yet. The European Convention on Human Rights of 1950 is a clear example, allowing individual applicants to bring claims directly before regional human rights courts. Under the 1966 International Covenants on Human Rights, individuals can, in some situations, claim rights directly under international law, expanding protection today. Sometimes non-state actors like colonies or protectorates have been treated as subjects, especially when they needed recognized legal status for relations internationally. International organizations rose as significant subjects in the 20th century, gaining legal personality and powers separate from member states in many cases. Examples include the United Nations globally and regional bodies like the African Union, each able to act and hold certain international rights or duties. The Universal Declaration of Human Rights of 1948 recognized many rights at international level, influencing states and giving individuals stronger legal claims over time. Still, individuals face limits in enforcing international rights. Often, enforcement depends on states, courts, or international mechanisms agreeing to act effectively together. So, in contemporary international law, states are not the sole subjects. international organizations, individuals, and some non-state actors have gained subject status. So what do we learn from this? Legal personality depends on function and rights, meaning states, organizations, and people can all be subjects in different ways. Let us quickly remember the main points. Who makes international law? Who holds rights or duties? And who may be treated as a legal subject today? We covered three theories. Realist saying states alone, fictional saying individuals alone, and functional saying multiple actors, with examples like ECHR and the UN. Keep exploring these ideas calmly. There is no rush. For more clear explanations and study help, gently check EduRev resources when you're ready.